Hi guys, we're back with chapter 2. Let me realign it. Um, so again, we're going to go through chapter 2. This is looking more into courts and jurisdiction. So we're going to look at the federal court system as well as the state court system. Our state courts have what we call limited jurisdiction trial courts. So this is what you think of when you think of a court. They hear matters of either a specialized or limited structure. So we have family courts, we have criminal courts, we have civil courts. The decision can be appealed to what we call a general appellate court. And then small claim courts hear civil matters involving a smaller dollar amount. So anything from $5,000, $7,500 would be the limit in California. General trial courts hear cases that are not within the jurisdiction of the limited trial courts. So they're going to hear our overall case courts. They record and store testimony and evidence, and decisions are appealable to the intermediate appellate or the state Supreme Court. So we're looking at criminal courts, and that's kind of the structure. Our intermediate appellate courts hear appeals from the trial courts. Remember, if it's a specialized or custom court, it's going to go up through that appeals process. They review the trial court's records to determine if there were any errors. But remember, no new testimony or evidence is permitted. No new testimony or evidence is permitted. They are only looking at what the trial court looked at. Then it can go up to what we call the Supreme Court. So they hear appeals from the appellate or intermediate courts. Again, no new testimony or evidence, and the decisions of the state Supreme Courts are final unless either a new question of law is involved or it has a constitutional validity that can go up through the federal Supreme Court. So our limited courts are tax, federal claims, trade, bankruptcy, armed forces, and veterans claims. Those are just some special federal courts. Our U.S. district courts look for trial courts of general jurisdiction. Again, they hear testimony, have juries, just like our state district courts, but they're at the federal level. Oh, one thing. Those judges have what we call lifetime appointments. So they are not taken off the bench. They are not reelected unless something happens. Again, the U.S. Court of Appeals are just like our state Supreme Courts. They're not going to hear anything new. It's a 3-judge panel. There are 13 circuits within the U.S. We are in the 9th district here, and they hear appeals from the federal district courts. The U.S. Court of Appeals, again, no new evidence, and they can choose whether or not to take the case. And then it goes up to the U.S. Supreme Court. They are located in Washington, D.C. They hear appeals from the federal circuit courts, special circuit courts, highest state courts. Again, no new evidence. They choose how many cases to take, and they only impanel for about 4 months out of the year. The Supreme Court is an appellate court, and the decisions are final. Decisions of the U.S. Supreme Court can be either unanimous, all of them vote the same way, a majority, which would be obviously the majority vote one way, a plurality, or a tie. So a tie would be both on one side. A plurality is not just enough to make a majority, it's just, maybe one judge over. And then the petition is called a writ of certiorari. This is how you get a case into the Supreme Court. So you have to fill out a writ of certiorari, and they look at that and then determine if they want to take the case. A justice who agrees with a case's outcome but differs in the reason for the decision can offer what we call a concurring opinion. So they say, yes, I agree to legalize marijuana, but not for the reasons stated in the decision. And then somebody who does not agree with the decisions would be a dissenting opinion. Federal questions are looked at by federal courts. These are anything from the U.S. Constitution, treaties, federal statutes and regulations, And in those particular cases, there is no limit on the dollar amount. The other way to get into federal court would be what we call diversity of citizenship. This is where citizens are coming from 2 different states, and the amount in controversy is at least $75,000. If you have those 2 elements, you can get into federal district court. Again, we're in the Ninth Circuit. Federal courts have exclusive jurisdiction to hear cases involving federal crimes, antitrust, bankruptcy, patents, and suits against the U.S. They can also hear cases on admiralty, but they normally only hear about those. Okay, so your book has the case of Hertz v. Friend. You're going to cover that in your case brief, so I'm interested to see what you think of that one. State courts hear cases that federal courts do not have jurisdiction to hear. So they can hear concurrent cases if there's diversity of citizenship or a federal question over which federal courts do not have exclusive jurisdiction. So maybe something happened within the state, but it has to do with a federal matter. The defendant can decide which court to hear a concurrent jurisdiction case in. Remember, the defendant or the respondent. An individual must have standing to sue, which means they must have a stake in the outcome. So you cannot sue on behalf of your daughter if your daughter's still alive and able to sue. The court must have in-person jurisdiction, meaning the parties must be within the jurisdiction that the state has availability to litigate over. So maybe they're located in California, they do substantial business in California, you would be able to bring a suit in California. A corporation is subject to personal jurisdiction in the state if they were incorporated there, have a principal office, or do substantial business within their borders. We have what's called a long-arm statute. This allows a state to have jurisdiction over a particular person or business if what we call they're doing substantial business or they come into contact with the state a lot. They must have minimum contact. So Amazon makes money in every state in the United States. We could use and sue Amazon using a long-arm statute, even if they don't have a principal place of business in the state because of how much money they make doing sales within the state. If an individual has committed a tort within the state, long-arm statute's going to apply. If they entered into a contract within the state, or if they caused injury in the state. So maybe you were just driving through, but you were in a car accident, so you're still going to apply. In rem jurisdiction, allows you to hear a case within the state because the property is located within the state. Maybe the individual is not, but the property is. And quasi in rem allows the plaintiff who obtained a judgment in one state to collect a judgment by attaching property in another state. So you win a judgment over an individual in California, but they have property in Arizona, you attach that to get paid. Venue is just where the case is being held, where it's being litigated. And we try to avoid what we call forum shopping or looking for beneficial areas to litigate. So we want to keep disputes in where they occur. And we'll look at Chanel v. Banks as well in the briefs. Let me know if you have any questions on those. Hopefully this was helpful. Email me with any questions or concerns about the assignments.